Are you a foreign national who's in a relationship with a U.S. citizen or permanent resident? Do you live overseas and hope to someday marry this person, come to the U.S. and live with him or her? Hi, my name is Dyan Williams and I'm an immigration attorney. Wherever you are in the world, I can help you figure out whether you qualify for a green card and help you get it. In this video, I'll talk about two types of visas that allow you to come to the U.S., visit your companion, and eventually get a green card. They are the B-2 visitor's visa and the K-1 fiancé visa. Here's what you need to know about the B-2 visitor's visa. This is for temporary visits only. To get the visa, you must show that you have non-immigrant intent. This means you have strong ties to your home country that you cannot abandon, and you plan to leave the U.S. before your authorized stay expires. The B-2 visa works if you are not yet engaged to the U.S. citizen or permanent resident. Here's why. When you fill out the visa application, you will be asked whether you have any immediate relatives in the U.S. A fiancé counts as an immediate relative. When you show up with a visa interview, the consular officer might ask you, what is the immigration status of this fiancé? If the consulate learns that you have a U.S. citizen or permanent resident fiancé, they might just deny the visa. Also, when you appear at the port of entry and present a B-2 visa, the customs officer might ask you whether you have any immediate relatives in the U.S. If they find out that you have a U.S. citizen or permanent resident fiancé living in the U.S., they might just deny your entry. The reason is that they might suspect that you have no plans to leave the U.S., that you'll simply overstay, marry the person, apply for a green card, and stay here permanently. And this is not the purpose of a B-2 visitor's visa. A general desire to immigrate to the U.S. is not really a problem. What is a problem is fraud or willful misrepresentation to gain immigration benefits. Here's an example. Let's say you are engaged to a U.S. citizen or permanent resident, and you have specific plans to come to the U.S., marry this person, and apply for a green card. If you show up to the B-2 visitor's visa interview and you tell the customs officer that you're only planning to come here for a temporary visit and that you have no immediate relatives in the U.S., this basically amounts to fraud or willful misrepresentation. If you present a visitor's visa at the airport and the customs officer is told by you that you're only here for a temporary visit and you have no immediate relatives in the U.S., this also amounts to fraud or willful misrepresentation. If the Immigration Service finds that you committed fraud or willful misrepresentation to gain immigration benefits, this is a lifetime bar to getting a green card. And the only way to overcome that is to apply for and receive an I-601 waiver, which is hard to get. The B-2 visa works if you decide to get married and apply for a green card after you've arrived in the U.S. Perhaps after spending some time with each other, you decide that getting married and living permanently in the U.S. is the right choice for you as a couple. If your spouse is a U.S. citizen, he or she may file an I-130 immigrant petition for you, and you may file an I-485 green card application at the same time. Your other option is to go overseas in a timely manner and apply for the immigrant visa once the I-130 petition is approved. If your spouse is a permanent resident, he or she may file an I-130 petition for you, but you would not be able to file for a green card right away because of the backlog. If you're in the U.S. and you are planning to file an I-485 as the spouse of a permanent resident, you do need to be maintaining lawful non-immigrant status until you're at least able to file the I-485. So what this means is you're going to be needing to extend or change your status, which can be very difficult to do. The other thing is you could wait until the permanent resident becomes a citizen so that you can file for an I-485 green card application right away. This is also very challenging. So most likely you will need to depart the U.S. in a timely manner and apply for the immigrant visa overseas once the I-130 petition is approved. For more information on the B-2 to green card process, hop on over to my website and check out my articles on my immigration blog or answers to frequently asked questions. If you need advice or help with this process, call me or contact me through my website at dyanwilliamslaw.com. Here's what you need to know about the K-1 fiancé visa. The K-1 is for you to come to the U.S., get married to a U.S. citizen fiancé, and then apply for a green card. It works only if you're engaged to be married and your fiancé is a U.S. citizen. If you're not yet engaged, or if your fiancé is a permanent resident, it doesn't work. Your U.S. citizen fiancé may file an I-129F petition for you so you may apply for a K-1 visa at the U.S. consulate. To get this petition approved, one of the things he must show is that you have met in person at least once during the 2 years prior to filing the I-129F petition. If you have not met in person at all during this period, you must qualify for and receive a waiver of the in-person meeting requirement, and this is hard to get. Also, when you come into the U.S. on a K-1 visa, you must marry within 90 days of your arrival in the U.S. If you do not marry within 90 days of your arrival, then you can no longer use the approved K-1 petition to apply for a green card. Instead, you must then get married outside the 90 days. Then your spouse must file an I-130 petition so that you may file for a green card. For more information on the K-1 to green card process, hop on over to my website and read my articles on my immigration blog, or read my answers to frequently asked questions. If you need specific advice and guidance on this process, call me or contact me through my website at dyanwilliamslaw.com.